Let everyone get settled. Okay, Mr. Bacarisse.
Thank you. May it please the court. When PNC, a sophisticated company with substantial experience in tax credit partnerships, signed the settlement agreement, it knew the clock was ticking on its ability to claim the then unissued 2016 tax credits. By the time of the settlement's closing, 2 of the 3 years of the look-back period had already passed. So in order for that 2016 credit to issue and PNC to benefit, TDHCA had to issue the Form 8609 within the next year. But PNC concedes the parties did not require that outcome. Eureka did not guarantee issuance of the 8609 at all, let alone by the deadline necessary for PNC to take advantage of the 2016 credit. Yet the district court held that Eureka nevertheless guaranteed a result dependent on the very thing Eureka had not guaranteed, namely that PNC would benefit from the 2016 credit regardless of whether or when the document necessary for that benefit issued. The settlement's text rejects that result, which is contrary to common sense. Had the parties intended to ensure PNC's benefit against all eventualities, regardless of whether or when the underlying credits issued, they would have said so explicitly, rather than render meaningless Eureka's obligations with respect to the...
So is your primary argument that PNC had promised they would effectuate it and they didn't deliver, or that you did your best and things outside your control, especially the Texas Housing Department not issuing it, just prevented you? But the understanding was that if you ran into an obstacle like that or the look-back rules, you didn't have to deliver the credits.
The latter.
It's the latter.
The latter.
Because when I read the hearings, it looked like you were suggesting that PNC had an obligation. They were lackluster. They didn't do it. You were blocked by the injunction and the Weiss lien, right?
Yes, Your Honor. That's an alternative argument. We've raised we've argued that the district court erroneously dismissed our defense, our prior material breach defense, and I think
that's secondary. Okay,
that's right. PNC's conduct goes.
So then the district court's ruling really stands or falls on its reading of your promise to deliver or for them to get the benefit of as a guarantee. And you're saying you can't produce a miracle? Is that it?
That's essentially our position. That not only could we not promise a miracle, the contract explicitly relieved us of the obligation.
This is the reasonable efforts clause.
It's a few things. That's part of it. But it's also just, it's the reasonable efforts clause with respect to the 8609 in particular. Yeah. In order for the tax credit to issue or for PNC to take advantage of the tax credit, you need an 8609, and then Eureka would claim the credits, and then it would issue a K-1 that allocates the credits that it's claiming. Without the 8609, PNC, or rather Eureka couldn't claim the credits on its tax returns. And because the contract says, Eureka, you don't have an obligation you're not guaranteeing the issue of 8609, it makes no sense to say, well, you're nevertheless guaranteeing the underlying benefit.
That's sort of an absurdity argument, right? Because issuance isn't what the language says. It really does speak of them getting the benefits. It's as if your client assumed the responsibility to get that credit to them. Right?
I wouldn't say that it's quite an absurdity argument. I think that there are both textual, structural, contextual reasons.
Good answer.
And we would say, first you can start with the text, which is, Eureka shall ensure the issuance of the 8609, or rather the issuance of the tax credit to the partnership and to effectuate PNC's right to receive, own, and benefit fully from the credit. Now, there's a few things about that. The word effectuate in legal context typically means something more like facilitate than it means guarantee. This is, I think, confirmed by the fact that you have immediately following that, you have a single example of what this supposed right involves, and that is the right or the obligation to sign documents required or reasonably requested by PNC. So this is something that's facilitative. It's not guaranteeing. You have this to effectuate language. It's not Eureka shall effectuate. It's Eureka shall to effectuate, which seems to make that obligation to effectuate the right to own and benefit something subsidiary to the obligation with respect to the 86.
But isn't, to the extent there's ambiguity, isn't it clear, no matter what, the settlement agreement couldn't modify the partnership agreement? So then if you go there, you know where I'm going, right? If you look at, I think it's section 3.5A1, that's pretty clear that PMC is going to receive the full amount of the tax credits.
So I think that that's not
No?
quite what that means.
Okay.
So it does say that it'll ensure that it receives the credit.
Yeah.
But then you have, I believe it's 3.5B5 that says Eureka's not responsible for PNC's inability to utilize the credit. And so the settlement agreement is the partnership agreement and the settlement agreement, we believe, is making a distinction between receiving, which they say is the K1, and benefiting. And it's saying, Eureka, you're not responsible for their benefit. You're responsible for facilitating the benefit. You're responsible for, so taking the steps that you can, but the benefit itself is not guaranteed. Related to that, you have, another approach you can take with respect to the district court's holding is that there's ultimately no causation here. The district court found that the omission by Eureka here was the failure to issue a K1 to PNC, which is something that we couldn't do until the 8609 issued. But the
But the 80609 required a lot of work with you in conjunction with the Texas Department.
That's right.
So I guess the reading might be that you had to do all that work. Hell or high water, you had to do that work. And you were willing to assume that risk so that 8609 would issue and you'd get that K1 in time to get, really we're talking about 2016, aren't we?
Yes, we're talking only about the 2016 credit.
Okay.
So the issue there, I think, is that, well, two things. First, again, there was no obligation to get the 8609, and there was no obligation to get the 8609 by any specific date. The parties decided, despite knowing that this clock was ticking, the parties decided not to impose any kind of timing term with respect to the 8609. In PNC, at I think page 27 of its brief, it acknowledges that it has never argued that Eureka breached its obligation with respect to the 8609 itself. So if getting the 8609 when it came is a satisfaction of Eureka's duties to effectuate the issuance of the 8609, then if we've complied, then it makes little sense to say that we have nevertheless breached by when the timing of that 8609 is what impeded their benefit and impeded our ability to issue a K1.
I mean, we're looking at the plain language, but I am curious, to the extent that it's in the record, this time period where critical things didn't happen, whichever party we attribute them to, was it more because of the district court's injunction with a pending builder's lien, or was it just because this Texas department was super slow in doing its work? Is that open to dispute? I
mean, it's open to dispute, certainly. The evidence, our evidence was that basically the 8609 was almost ready to issue at the time the district court entered its injunction in 2017, and then nothing happened for 2 years, and it took a lot of effort to get them re-engaged. That's the other side says that it's the lack of permanent financing. Our witness disputed that, and the district court didn't really resolve that.
Your witness is Stanley?
That's correct.
Am I right that Stanley, when he was under oath, he said there's no modifier to the language focused on by the district court? In other words, there is no modifier adjacent, suggesting reasonable efforts.
I don't recall that testimony. I'm not sure that it's relevant because I don't think a witness, an attorney witness or not can,
Well, if your attorney witness, who's the one who helped draft these agreements, said, well, you're right, there's no modifier to the tax credit guarantee given in 2B.
So, I think that Eureka's position throughout the district court was certainly that when you say no modifier, I guess...
As in reasonable efforts. Instead, it was a categorical guarantee.
So I don't recall that particular testimony. I
may be wrong.
Certainly Eureka's arguments below were that the reasonable efforts clause applied. But even if it didn't apply, ultimately, even if our failure to issue a K1 is a breach of either 2B or Section 11, that failure to issue the K1 didn't cause PNC's damages. Because had Eureka issued a K1 once the 8609 issued and it was able to issue a K1, they couldn't have benefited. Their own witnesses testified that they couldn't go back and amend their returns. So the failure to issue the K-1 once it was able to be issued is not the cause of their damages, which I think is an independent ground for.
Because they'd revised their return, right? Not having the benefit of the K-1 form. You're saying they couldn't have then gone.
So that was 2015.
2015 is out of the picture.
Right. 2016, my recollection is that they never claimed the credit at all.
Okay.
They were in charge of the partnership at the time that the returns, both the partnership's returns and their own returns, were filed in 2017. And then the look-back period ended in 2020.
Are you focusing on the Section 2 ruling because either the Section 2 or the Section 11, they're independent grounds?
That's right. We agree they're independent grounds.
Okay.
And I can take up 11 too. So with respect to 11, this is the...
Well, you have some time left, and I know I'm interrupting your discussion with Judge Higginson,
No.
but there's I think there's still a jurisdictional problem here. I'm looking at your jurisdictional statement in your brief. You say the district court has ancillary jurisdiction to enforce a settlement agreement when the court expressly retains jurisdiction. That's true, but this action was severed for the settlement, right? I mean,
So-
it was a severed action.
It was severed, yeah, at the same time, Judge.
Well, so I mean, we have a case called Honeywell versus Phillips Petroleum, Fifth Circuit, 2005. The citation is 415 Fed Third 429, and what it says is that you have to have an independent jurisdictional basis for a severed action. Your brief suggests that the jurisdictional basis, which was originally jurisdiction, doesn't really apply anymore. Those are my words, because the court retained the jurisdiction that it already had. But this Honeywell case suggests that you have to independently establish jurisdiction. I'm not sure that's been done as to all the various entities that may be involved here.
I apologize for not being familiar with the Honeywell case. I do think that there is diversity here. The PNC and SLP, Columbia SLP, they're Oregon and Pennsylvania entities, and then all of the Eureka parties at this point in the partnership, since they are no longer parties, or they're no longer part of the partnership. All of the remaining members of the partnership and those entities are Texas citizens.
That was sort of pleaded generally, but it wasn't specifically stated as to each entity, I don't believe.
I would acknowledge that. I think
it said on information and belief or something like that, maybe. But.
So I think that it wasn't information and belief, but there was, I agree, there is nothing in the record that substantiates, that states who all of the members are of, I think, Chula. So there is one entity where that's true of. But the retention of jurisdiction, I would think, is the independent ground for.
And I just don't think you can do that under Honeywell. But
okay, understood. If I could just address Section 11 very briefly, sure. The breach there was failing to indemnify from them for damages resulting from a failure to deliver the tax credit. The provision doesn't say who's delivering what to whom. I think to understand what deliver means, you need to look back to the settlement agreement. And the settlement agreement, when it uses the word delivery in the context of tax credits, is clearly not referring to the K-1. It is referring to something that occurs before the K-1. This is, I think, 3.5C2. And these are saying, if they are allocated more credits because of an earlier than anticipated delivery of the credits, things change with respect to capital contributions. The point being that delivery here is referring to the issuance. It's not referring to the K-1. Anything further?
All right, you say time for a vote.
you.
Thank you. Mr. Cox.
Thank you, Your Honors. May it please the Court. Trevor Cox from Hunt and Andrews Kurth on behalf of the appellees. I have a few points I'd like to make. First, I want to remind the Court that the overriding purpose of the various agreements in this contract dispute was for the PNC parties to benefit fully from the tax credits, which, it's not disputed, were never delivered. Obviously, that didn't happen, and Eureka knowingly and expressly took on the contractual obligation to shoulder that risk. Second, I want to address some of appellant's points, including that the relevant standard for Eureka's conduct was only commercially reasonable efforts, and that, I think we heard some allusion to it, that the PNC parties committed a prior material breach that excused Eureka from its obligations. So first, to remind the Court, take a step back of the overriding purpose of the variety of documents that are before you in the record that show that the purpose of this enterprise was to obtain favorable tax credits. That was the purpose of the partnership agreement, the settlement agreement, the tax credit guarantee that the parties entered into. So the settlement agreement, we've already talked about Section 2B, Eureka parties shall effectuate PNC Bank's right to receive, own, and benefit fully from the retained tax credit. The Eureka parties also pledge that they shall comply with the terms of the partnership agreement, including the guarantee as it relates to the tax credit obligations regarding the tax credit. That's also in 2B. And so the reference to the partnership agreement there requires that the general partner timely ensure that the investment limited partner PNC Bank receives the full amount of the forecasted tax credit. That's partnership agreement 3.5A1.
But sort of just factually, they couldn't coerce the Texas Department to move quickly or slowly. You're saying they assume that risk?
That's correct. These deals are often dependent on the activity of, in this case, the TDHCA to issue tax credits. And clearly, at the time that they took over the partnership again and entered the settlement agreement, they knew that the 8609s had not been issued. They were given the opportunity to do the due diligence, to examine what their communications had been.
Still?
I think they had about a year, actually. I think the settlement agreement was closed in September.
The 2015 tax credits couldn't have been attained.
Correct.
And you're not saying there's a breach inherent in that?
There was a breach, but we released the claim because at the time of the settlement, we released all claims that had existed then, and so.
So is the reasonable efforts language just surplusage?
I wouldn't say it's surplusage, but it is additional, and in the context of all the other agreements that the Eureka parties made, it doesn't obviate all those things. The Court has already noted, Your Honor has already noted that.
What does it modify?
It modifies effectuating issuance of the tax credit.
And so isn't that their argument? They couldn't effectuate issuance of this critical 8609 document.
That's right, but they had independently pledged to make sure that the PNC parties benefited fully from it.
I understand that, but it does seem then it's sort of striking out that sort of clawback, right? You've guaranteed we'll get it no matter what. We've agreed that you're just going to take your best efforts at getting issuance of the critical document.
Mm-hmm. So the commercially reasonable efforts applies to Romanet 1 in that section 2B, does not affect all the other language earlier in 2B that Eureka parties, quote, shall effectuate their right to receive.
But it does affect the issuance.
Correct.
And they couldn't get you the benefits without the issuance. It seems a little circular. No?
That's right. I mean, I think it's a sort of belt and suspenders approach. I mean, they could have agreed to, in addition to committing to making sure that PNC got the full value and own and benefit fully, et cetera, there could have been a provision that said the Eureka parties shall call the TDHCA every Tuesday at noon to check on the status. And I don't think we'd be saying that is all that they're required to do. They have all these other obligations.
Is it relevant to our assessment of the district court's ruling that it made an alternative finding that there wasn't corroborating evidence of the witnesses' statements that they tried hard? Does that am I correct about that district court remark? That it said alternatively, even if we were looking at reasonable efforts, I don't see evidence corroborating the witness testimony that they worked so hard.
Yeah, I think that was sort of
afterthought.
Yeah, throwaway footnote.
So that really doesn't affect
and-
our statutory language, I mean, our textual language.
Correct. We don't think commercially reasonable efforts apply at all to their overall obligation. Again, apparent throughout all the documents that the purpose of this was to make sure that the PNC parties benefited fully. That is what underlies the tax credit guarantee as well. All these things that were entered into.
And benefit fully is language in both the settlement agreement and the underlying partnership agreement?
I think the language in the partnership agreement, I don't want to misquote it, Your Honor.
Because it
The
seems to
partnership
be really
agreement-
clear the settlement agreement says nothing here modifies that. So
That's-
in many ways, that's even more fundamental document as to whether there's a breach or not.
Yes, the language in the partnership agreement, this is at 35A1, they'll shall ensure that the ILP here, PNC Bank, receives the full amount of the forecasted tax credit.
Okay.
And then the partnership agreement in Section 1.4 also said that the overriding obligation was to ensure the availability of the tax credit. So that's the partnership agreement, which again is incorporated by the settlement agreement. And then you have the tax credit guarantee, which guaranteed that the PNC parties would receive the forecasted tax credits. And of course the indemnification language there, and the definition of tax credit shortfall and the tax credit guarantee was also made part of the settlement agreement. In fact, part of the closing deliverables in the settlement agreement, and this is at Section 12, is that they require documentation of showing that the retained tax credit shall be effective and retained by the respective PNC party. So you have this network of documents that show that the clear purpose of this transaction was to make sure that the PNC parties got the full credit for those tax credits.
You agree?
But if that didn't happen, there was an alternative method of adjustment, which was downward adjustment to the PNC's capital contribution, right?
Yeah, so we think, Your Honor, that that's another way of showing that PNC party gets to benefit from the value of these things, and
But that would also mean they might not be getting the tax. I mean, it was anticipated that they might not be getting the full tax credits. So this was a way of compensating on the capital contribution.
I think, Ron, I may be mistaken, but does that have more to do with the allocation rather than the delivery of the tax credits? I heard my friend on the other side, for instance, talk about the PNC party's inability to utilize the tax credits, but that has more to do with after they've been delivered, do they have sufficient income to be balanced out by the tax credits? And so, the whole web of documents that everyone entered into showed that the purpose of this was to make sure that the PNC parties got the full benefit. And the fact that the commercially reasonable efforts only applied to the 8609 issuance doesn't render all those other language and provisions meaningless. I think that's a basic principle of contract interpretation. I heard my friend on the other side also refer to what the holdup might have been during the previous.
I asked about that.
Yeah, I think it's a relevant one, right? Because at the time of the settlement agreement, all that is, as the district court found, totally irrelevant because we're sort of moving forward from that. But there was testimony that Mr. Stanley said that before the litigation was filed, the Weiss litigation, that in his estimation as a professional, they were 60 to 90 days away from the 8609s being issued by the TDHCA. That's at record 2410. And so that litigation was pending until September of 2019. The PNC parties retained control of the partnership. In part, my understanding is to make sure that litigation got resolved. And so by the time it was handed back to them, that litigation was no longer an impediment.
But it was handed back to the Eureka parties.
Correct.
This does bleed into their prior material breach argument, though, because they're saying, well, you had it for all that time.
Yes, but the evidence was also that the litigation was the impediment to the TDHCA actually issuing the 8609. And so for the entirety of that time that the litigation was pending, the 8609s were not going to be forthcoming. So by the time that was resolved and it was handed off,
Stanley's 60 to 90 days. should have been able to.
That's what the evidence was. Yes, Your Honor.
Before you get to your next issue, do you agree with your friend opposite that ruling on either the Section 2 or the Section 11 breach, each is an independent ground?
Yes.
Okay.
Yes, Your Honor. I think the court made that pretty clear below. And there's, good reasons to affirm on that ground as well. I think I've covered most of what I'd like to address, unless the court has further questions for me.
Did you discuss the jurisdiction issue?
Sure. So I also am not familiar with the Honeywell case, I believe Your Honor mentioned. But our understanding, as evidenced in our brief, was that because the court had jurisdiction until the point of severance, that the ancillary jurisdiction carried over. And I think the case we cited from the U.S. Supreme Court was Kekkonen, which may not have been in the exact context of Honeywell, but because the court had jurisdiction over that matter and it was properly before them, then it also carried over. I also agree that with my friend on the other side that the allegations of Chula Investments membership were not entirely clear, but there are filings that have been made in this case and other cases where the citizenship of Chula Investment has been taken to be Texas. One example of that is in the notice of removal in the state court case that was 117 CV 1081, where the removing defendants, which included Chula, said at the time the state court action was filed and at all times since, all of the removing defendants have been citizens of Texas. So I think everyone's working understanding has been, and the district court accepted that Chula was a Texas citizen.
To resolve that with confidence, are you saying that we need to look at supplemental or take judicial notice of something, or are you saying that legally on information and belief is sufficient? What's your argument? If Chula wasn't entirely clearly briefed as to the citizenship of its members, we still have diversity jurisdiction because on information and belief, as alleged, is sufficient legally, or because you would be now pointing us to supplemental proof?
I think that was in addition to what has been pled here, and I think on information and belief was the allegation, but I believe in the answer, docket 78, the defendants admitted the citizenship allegations in those paragraphs.
So on the answer, docket 2 and 8, I'll see more proof as to best efforts or actual citizenship as to members.
I'm sorry, best efforts?
When your answer is, it's in document 78, which I'm not having a mental image of.
Yes. So this was an answer to the amended complaint where the citizenship allegations were made.
Yeah.
Including that Chula was a citizen of Texas.
Okay.
And then
let's say there weren't that answer. So it's just the on information and belief. Legally, is that sufficient or not? Are you informed to be able to answer that? Have other circuits said that it is, or you don't know?
I do not know the answer to that, Your Honor.
That's fine. We'll figure out jurisdiction. We have to.
Sure.
Thank you, Mr. Cox.
Yes, thank you.
Mr. Bacarisse, rebuttal.
Thank you. Just a few points. I want to take up Judge Higginson's point about surplusage, because I think this is an important point about the structure of this agreement. Certainly it was the case that the parties were concerned with getting and distributing these tax credits. But precisely what was guaranteed and what was not is crucial here. And the parties went through the trouble in the settlement agreement of including this, for the avoidance of doubt, the obligation to effectuate the issuance of the tax credit is subject to commercially reasonable efforts. They clearly cared about that, and yet my friend on the other side says that essentially has no meaning in this contract, that there is never, that I can imagine, and he has certainly not given an example, of a circumstance in which that language would relieve Eureka from liability. Because no matter what Eureka did, no matter how innocent it was in failing to get the 8609, they say that the second clause absolutely guarantees that benefit, and that essentially reads out the effectuate 8609 language. There's a better construction of the entire agreement to say that what the parties were concerned about here was the possibility that Eureka, because it is the entity in charge of the partnership, might not get all of the credits from TGHCA because it didn't comply with some of the requirements about tax credits, or then it might fail after the credits were issued and then have credits clawed back. That was the concern. And they were saying and so they were concerned about the issuance of the 8609, but they weren't saying we're absolutely guaranteeing a benefit. I'd also add that, I think that with respect to the commercially reasonable means language, there is indication that this is essentially a subsidiary right or a subsidiary obligation to the obligation to effectuate the issuance itself. There is as I mentioned, the to effectuate language. It's not shall effectuate, it's shall effectuate the issuance to effectuate the issuance of the right to benefit fully, etc. There's also the language, it's not effectuate the benefit, it's effectuate the right to benefit. As of the time the 8609 issued, there was no right to benefit because the look-back period for them to amend their taxes had passed. And then I want to point out the First Amendment to the settlement agreement, which they say we were just guaranteeing this benefit. That includes language that says what the parties would have done was that their intention. With respect to the 2019 credits, the First Amendment says if the parties can't agree on how Eureka will benefit from the 2019 credit, PNC has to pay them money. And it just says you have to pay them, and you pay them this amount. If that were their intention with respect to all of the other credits, that's the language they would have used. Judge Smith, you asked about this downward adjustment stuff. And so, for example, 3.5B1, it says if the ILP if PNC will not be eligible to be aggregated as much as it expects, its capital contribution is reduced. I think you're right here that the point was, yes, we have to ensure that they receive the tax credit, but if the cause is that they're not going to get as much as they expected, the way that was adjusted was through capital contributions and things like that, and those provisions specifically survive the settlement agreement. All of 30.5 does. They've never made a claim under that or anything like that. And then I just want to very briefly come back to the jurisdiction point. One thought there is, the allegations in the original case with respect to Chula in particular were probably insufficient. Nevertheless, the district court in that case ruled that the court had jurisdiction. And I suspect that ruling is res judicata. Jurisdictional rulings under the restatement can be res judicata, and so that would be our submission with respect to that.
Okay, just to clarify that answer, so you're saying, from your assessment of the law, the on information and belief was insufficient, and yet what? Or
my recollection is that I thought this court had held that information and belief. You can't plead jurisdiction on information and belief, but if I'm wrong about that, I wouldn't have thought that pleading was sufficient. I thought you had to actually go through and show who the...
So you're not sure about that answer?
I can't say that I'm confident in that answer.
But your fallback is, even if we've said that, then what?
Then res judicata. The district court found jurisdiction, and that finding is entitled to res judicata with respect to the membership of Chula.
The only problem with that is that we have a continuing obligation to examine not only our own jurisdiction, but the jurisdiction of the district court if we think that there's an issue with it, even if the parties otherwise agree that there's...
May I just respond very briefly to that? I certainly think that's right. I think the case law is that there was no appeal from that judgment in the original district court proceeding. And so the district court's determination in that proceeding is what I'm saying would be subject to res judicata because there's been, it wasn't appealed, it's final. And I think it binds the parties in this case.
All right, thank you.
Thank you.
Next case, Doherty versus Silver Fern